call the next case, please. Ms. Newton, whenever you're ready.
Good morning, Your Honors. My name is Mary Newton. May it please the court. I'm here for my client, Mr. Eugenio Gomez Ruiz. I'd like to reserve 5 minutes for rebuttal. This appeal follows a jury trial in which the defendant was tried for rape and furnishing alcohol to a minor. He was only convicted of the alcohol charge. Now, I would like to spend some time talking about what happened because there are a lot of moving parts here. So the presentment alleged that on February 15th, 2020, the defendant unlawfully furnished an alcoholic beverage to a person under 21 years of age, to wit, Aaron Connor, in violation of TCA 57-4-203. Now, at trial, it was established that on that night, February 15th, 2020, Aaron Connor, the person named in the presentment, and her friend, Miss Holloway, went to El Mezcal Mexican restaurant in order to have a girls' night and get some alcoholic drinks. They were seated at a booth where they were served by a female server who Miss Connor greeted with familiarity. They ordered liquor drinks. The female server made those drinks at the bar, served it to the women at the booth. The testimony established that this was not the first time that female server had served Miss Connor, that Miss Connor had drank liquor drinks at the restaurant before, and that at her first time drinking at the restaurant, she had shown an ID and had not been subsequently carded. On this night, the defendant, Mr. Gomez Ruiz, who was an employee of El Mezcal, was sitting at the bar. Now, Mr. Gomez Ruiz was a cashier, host, sometimes cook. He was at the bar near the booth that the women were sitting at, and at one point in the night, he joined Miss Connor at the booth for a few minutes, then went back to the bar where he sat. The restaurant closed at 10:30. Around 10:40, the women joined Mr. Gomez Ruiz at the bar with some other people. Mr. Gomez Ruiz directed the bartender to pour Miss Connor an alcoholic drink with the liquor that she selected. And over the course of the evening, Mr. Gomez Ruiz filled her glass twice with liquor. Now, I'm here because I believe that there were some errors down below. So first, on cross-examination, the defense asked Miss Connor if that ID that she had shown at the prior visit had reflected that she was of a legal age to drink. The state objected. The court sustained the objection, saying that it was irrelevant and the question violated the Shannon-Christian Act. We were able to make an offer of proof in which Ms. Connor did testify that, yes, she had used an ID that reported she was of a legal drinking age the first time she went to the restaurant. Additionally, the defense filed a jury instruction, which reflected a affirmative defense found in 3915-404, which is another provision under the law that governs providing alcohol to a minor. The jury instruction also included mens rea elements that the jury would have had to find. The court denied the request for a jury instruction, saying that the court found that it was a strict liability offense. The court actually said, I think I'm right on that, but if I'm not, nobody's going to really care because it's a misdemeanor and we're dealing with, a B felony rape. Ultimately, the court also did not...
How is it not a strict liability offense?
I would love to explain to you why I believe it's not a strict liability offense. Okay.
Please do, yes.
So, I think the central issue here is that there are two Tennessee laws that govern the same conduct, which is giving alcohol to a minor.
Let me push back on the premise.
Yes.
That's not necessarily true, right? One of the laws governs the conduct of a licensee. The other law governs the conduct of you and I. So there are not two separate laws governing the same conduct. There are two separate laws that are governing the conduct in two separate situations. So how do you respond to that?
So if I may respectfully push back on that, the text of 40203B1A says any licensee or other person who sells, furnishes, disposes of, or gives alcohol to a person under 21 years of age commits a Class A misdemeanor and shall be punished in accordance with 3915-404. This is the statute that Mr. Gomez-Ruiz was indicted under. And I believe that other person means other person.
He's a licensee also, though, isn't he?
Well, Your Honor,
He has
I
a
might need
license.
you to explain to me what licensee would mean in that context for
I mean,
him
come
to
on,
be.
counsel. I mean, this is your burden in the appeal. I'm trying to figure out why you think this is not a strict liability offense. So I look at 574203B1A. I see no mens rea.
Correct.
How is this not a strict liability offense?
Okay. So I think there are two different ways that we discern that there is a mens rea requirement. So first of all, TCA 3911-102B declares parts 1 through 6 of this chapter shall apply to offenses defined by other laws unless otherwise provided by the law. Within part 3, in TCA 3911-301, subsection B says, a culpable mental state is required within the title unless the definition of an offense plainly dispenses with the mental element. Subsection C declares, if the definition of an offense within the title does not plainly dispense with the mental element, intent, knowledge, or recklessness suffices to establish the culpable mental state.
When they say within the title, do they mean Title 39?
Presumably, they do mean Title 39, but
I mean, in fact, this court has held that in Allman here recently, right? That the phrase within the title means offenses that are listed in Title 39. This is an offense listed in Title 57 by the plain language. This doesn't apply to Title
except
57.
that TCA 3911-102 says that parts 1 through 6 of the chapter apply to offenses defined by other laws. So I do believe that it does not have to be within the criminal code for things within the criminal code to apply if we're talking about something that is a crime, right?
How do you distinguish Allman?
I'm sorry, I'm not familiar with that case, Your Honor. I
That's fair.
apologize.
Okay.
I can look into it and submit a post-hearing briefing if the court would like me to.
All right, let's assume, just for sake of argument, that the no mens rea is properly imported into Title 57. How is this not a strict liability offense? Let's say that, in other words, let's say that we very respectfully would disagree with you that we have to import a mens rea.
Okay.
Do you lose?
Well, if I may, Your Honor, I believe that we arrive at the conclusion that there is a mens rea requirement through another vehicle as well. Can I explain that to the court? Okay. So under the indicted statute, 574203B1A is specifically facially linked to TCA 3915-404. The word is that any person who furnishes alcohol to a person under 21 years of age shall be punished in accordance with 3915-404. 3915-404 governs the same conduct as we have discussed.
And
it
again, the
also
plain language of that says it's limited to the punishment. I don't see how you get from punishment to the mens rea.
So I do think the wording is important. They didn't say sentenced, they said punished. A person would not be punished under 3915-404 if they had a reasonable belief that a person was over 21 years of age. That's in subsection C, the affirmative defense of reasonable belief. Subsection D is the penalties for violating 3915-404.
Let me just ask you then, because what you're raising is interesting to me. Under 574203, identify for me the elements that have to be proven beyond a reasonable doubt to the jury, please.
That a person, I'm so sorry, if I can just pull up the jury instruction I drafted.
Or the language of the statute.
Under the language of the statute.
What are the elements necessary for the jury to find beyond a reasonable doubt necessary for conviction under 574203?
That another person has furnished alcohol to someone under the age, as Mr. Ruiz was indicted, furnished alcohol to someone under the age of 21. And I believe the element of that the conduct was reckless, knowing, or intentional,
And you're getting there because of an affirmative defense in 3915404?
as well as 3911-102B and
Okay,
3911.
for purposes of my question, let's assume that
Yes.
and I'm not saying the court does, but let's just assume the court disagrees with you about importing mens rea.
Okay.
We're talking here because an affirmative defense in 3915404B, that affects the elements necessary to be proven beyond a reasonable doubt in 574203?
I don't think it's just the affirmative defense under subsection C. I think it is also the fact that the entire statute under 39 is, I think we can all agree that it is imputed a mens rea under 3911-301 because it is within the criminal code.
I'm trying to figure out, you said that you had two bases for imputing a mens rea. The whole
Yes.
discussion goes back to is this a strict liability offense?
Right.
And so we've discussed borrowing mens rea from another statute. I've placed that on the table for right now, very respectfully.
Okay.
And so now we're talking about the affirmative defense then, right, in 3915404. But an affirmative defense is not an element the state has to prove beyond a reasonable doubt. So your client still could be punished, even under your theory, by simply proving that he was a licensee or other person, that he sold, furnished, or disposed, or gave alcohol to another person under 21 years of age. Those are the elements the state has to prove. The state doesn't have to prove or disprove the existence of an affirmative defense. So the argument that you're raising that punishment is different from sentencing really doesn't hold here, does it?
Well, I respectfully disagree.
No, please do, yes.
So I believe that, as I mentioned before, that the legislature didn't use the word sentence, they used the word punished. They didn't cite specifically to subsection D, which is where the penalties under 3915-404 are. But further, they didn't even broadly make a language or say punished with the same penalties as 3915-404. They cited the statute in its entirety, and I believe that we are obligated to interpret the statutes in tandem, looking at 3915-404 in its entirety. And, Your Honor, I do understand the argument you're making about the affirmative defense, but I do think that it's important to note that the legislature wrote in a mens rea element might be the wrong word. The legislature cares about the mens rea of the person furnishing alcohol. The fact that there's the reasonable belief affirmative defense shows that. And I think that the trial court, affirmative defense or not, had an obligation to instruct the jury fully on general defenses, including mistake of fact regarding the defendant's reasonable belief that the person was over 21 years of age.
If we're talking about what the legislature believes, which I'm not sure is appropriate if the text of the statute is clear, but even if we do that, isn't it fair to say that the legislature might treat persons differently in a regulatory portion of the code than they would John Q. Public in the criminal portion of the code? That people who are licensed to serve alcohol are going to be held to a more exacting standard than just some guy at a party who might be handing out beers.
Right. So I understand. So I think it is important to note that Mr. Gomez Ruiz, while he did work for the restaurant, he was not serving Ms. Connor in his capacity as being a server or a bartender. In fact, he wasn't a server or bartender. He was a cashier, sometimes cook, sometimes host. Further, I don't believe that this 574203 is solidly placed within the regulatory scheme because it has a serious mandatory consequence. It's not a petty offense. If somebody violates under B1A, under subsection J1, there is mandatory jail time of at least 30 days up to 6 months.
DUI is also a regulatory offense. It carries mandatory jail time. It carries up to 1129. It is also a strict liability offense.
DUI doesn't have an identical corollary within Title 39 that I'm aware of.
This isn't an identical corollary, counsel. This is any licensee.
And if
It's
it
not
is
identical.
identical, I'm sorry,
Go ahead,
Judge.
Judge, I'm sorry.
If it is identical, then what's the purpose of 574203? Why even have it in the code? And
So-
don't we have a duty as a court to interpret the statutes in a way that give them meaning and avoid redundancy?
Yes. And Your Honor, I think that, again, Your Honor's noted maybe we ought not go into what the legislature was thinking, but the reality is that both of these statutes exist. I believe the other person language within 574203 is how my client was charged, not as a licensee, but as another person, which would, in my interpretation of 3915-404, have put him under 3915A2 as a person who gave alcohol to a minor.
Hasn't the legislature specifically contemplated the idea that they might regulate or criminalize the same conduct under different statutes? And unlike my friend from Chattanooga, I've not memorized the criminal code, but I believe the legislature has said when that happens, the person can be charged under either statute. Isn't that just what happened here?
So I do think that there's a distinction to be made in that the legislature has these two statutes, which I think could have been applied equally to the conduct the state has charged Mr. Gomez-Ruiz with. However, the rule of lenity comes into play. We know there's case law that sometimes there are statutes which create ambiguity with each other.
Where's the ambiguity in 203? What term in 203 is ambiguous?
The fact that it does not specifically have language going to mens rea, but 3915-404
There's
does.
no term in 574203 that is ambiguous as applied to this situation, right? The defendant, whether he was a licensee or other person, provided alcohol to someone who was under 21 years of age. Where's the ambiguity in this statute such that the rule of lenity would possibly apply?
I think it's the language that the conduct shall be punished in accordance with 3915-404.
What's ambiguous about that?
I think that it creates ambiguity whenever you look at 3915-404 and see that there is a subsection regarding mens rea, and also that it's within 39, so it has the imputed mental element.
Don't we also know that the legislature does this from time to time? And I see that your time is expiring, but I'll ask the presiding judge if she'll
Yeah, I
allow
think
just
we'll
a
give
little
you
bit
some
of-
extra rebuttal.
little bit
We've
of
asked a
extra
few
time.
questions.
So the legislature does this from time to time. It will reference punishment provisions in another statute to punish substantive conduct under another statute. Most recently, for example, in a case, State versus Fletcher from this court, defendant was convicted of insurance fraud. Insurance fraud provides that it shall be punished as in the case of theft, and cites the statute. When you flip over to the theft punishment statute, it is punished on the basis of property obtained. And so the argument in Fletcher was, well, if I didn't obtain property as a result of insurance fraud, I cannot be punished. And this court rejected that because it rejected it on a number of grounds. And the Supreme Court may weigh in on it, but this court rejected it, saying that when a reasonable person reads the statute, we're not importing elements in when we're talking about how it's going to be punished, what the consequences of violating the statute are going to be. And so isn't the most reasonable reading here, one that an ordinary person would give it, when it says a person shall be punished, is you're importing only the punishment principles in the other statute, not the substantive elements from the other statute, and certainly not the affirmative defenses from the other statute. Isn't that the most natural reading, particularly when you consider Fletcher and maybe other cases like it?
Well, Your Honor, respectfully, if I follow up on those cases, and if the court would like a subsequent post-hearing brief, I'd be happy to oblige.
It
But-
does. I mean, it follows also, not to interrupt, but it follows also in the case of vandalism. It follows also in the case of credit card fraud. I mean, it follows in a lot of different cases. This is not a one-off situation. And in every single one of those cases, this court is interpreting those statutes to apply only to the punishment provisions, the sentencing provisions, not to the substantive elements, and certainly not to affirmative defenses. I mean, theft itself has a whole separate statute in 3914-107 that deals with affirmative defenses to theft. No one ever thinks that those apply then in a case of insurance fraud.
So
Possibly.
I believe the issue is that the legislature did not specifically say sentence, they did not specifically say subsection D, they did not specifically say in accordance with the penalties of 3915-404. I do believe the statute must be interpreted in its totality when we are interpreting 57-4203. I know
Fair
I'm
enough.
far
Thank you,
over my
counsel.
time, so.
No, thank you, counsel. Thank you.
Thank you.
My apologies.
Morning, Your Honors. May it please the Court. Garrett Ward here on behalf of the State of Tennessee. Your Honors, I think I want to start my time this morning by referencing something that my friend on the other side said, because I think that really gets right to the heart of this case. These two statutes exist, and then Judge Hickson, your response was, well, doesn't this court then have an obligation to read these two statutes, the two statutes being 3915-404 and then 57-4203? Doesn't this court have an obligation to interpret the language of those statutes and give them effect? And the answer to that is yes. And Your Honors, I think what this case really boils down to is the defendant is unhappy with a discretionary decision made by the prosecutor to charge him under 57-4203 instead of a similar offense in Title 39. But ultimately, that is just a discretionary decision for the prosecutor to make within the bounds of certain constitutional strictures, which I frankly don't see at play in this case. And really, that's what, there are sort of a number of complaints revolving around this, but the center of this case is that decision by the prosecutor. That decision was a proper exercise of discretion. On a number of occasions, this court has noted, and the General Assembly has noted, that one behavior can be covered by multiple statutes, and when that's the case, it's the prosecutor who we task in the state of Tennessee with the discretion to choose who to charge with what.
General, isn't that question waived, though? I mean, I understand you're saying at base, this is a question of prosecutorial discretion, but isn't that question waived? That was not objected to at trial. It was not in the motion for new trial. It doesn't ask for plain error relief. Isn't that question waived?
As far as a direct challenge to prosecutorial misconduct, I believe it's absolutely waived, Your Honor. The reason I wanted to start my time discussing is because really I think the questions revolving or concerning the affirmative defense and the mens rea, I think they really all revolve around that central decision. A challenge to that decision would be waived. I saw no objection in the trial record and didn't really see one, from my read of the motion for new trial, didn't really see a challenge to sort of prosecutorial misconduct or prosecutorial discretion. So the ultimate decision itself has, the discretionary decision itself has been waived. These decisions that revolve around it, these challenges that revolve around it, that's what has been preserved, but they do sort of revolve around this court decision, which can't be challenged at this stage. Turning to sort of these revolving challenges, I think there's really three things going on here. One is the suggestion that somehow 3911-301, I believe that's the right statutory site for sort of the default state of mind, that might apply in this case. The second and third things going on are that the statutes, that Section 203's allusion to 3915-404 for purposes of punishment, that somehow incorporates the mens rea requirement of Section 404 and the affirmative defenses of 404. And if I'll address each of those in turn, starting first with the suggestion that sort of the statutory fill-in mens rea might apply here. Your Honors, it simply doesn't. That statute limits itself by its own language to crimes that arise in Title 39. This crime arises in Title 57, outside of Title 39, therefore unaffected by that statute. And this court did reach similarly the same result in Ullman, I believe about 3.5 weeks ago. That dealt with the, I believe, unauthorized practice of law statute, also arises outside of Title 39. And this court rightly concluded, and I believe both parties in that case conceded or agreed that this sort of Title 39 default, reckless fill-in just simply didn't apply to the unauthorized practice of law statute because it arose outside Title 39. The same is true here. As for the suggestion that somehow the mention of the Title 39 offense for purposes of punishment incorporates the mens rea or the affirmative defenses for that Title 39 offense into this Title 57 offense. Your Honors, I see very little in the actual text of 57.4203 to support that contention. When this section sets out its elements, which are simply that a person, furnishes, sells, or provides, or caused to be furnished, sold, or provided alcohol to a minor, those are the elements it sets out. It makes no allusion to the Title 39 offense when setting out its elements. Makes no allusion to the Title 39 offense's affirmative defenses. It does after setting out the elements. One of which is not a mens rea. They're notably absent from this statute, at least this subsection of this statute is mention of a mens rea. There's no allusion, there's no cross-reference to this Title 39 offense when we're talking about elements. And I think that's fairly telling that the legislature, when writing 57.4203, talks about its elements, specifically doesn't talk about a mens rea, and then afterwards says, when we get to punishment, do the same thing that we do for the Title 39 offense. That is, Your Honor rather beat me to the punch by referencing the Fletcher case. That's the same way that the General Assembly has formulated the punishment scheme for insurance fraud, I believe credit card fraud as well. Off the top of my head, vandalism works the same way. And at no point has this court or any Tennessee court ever found that specific reference to punishment provisions incorporates affirmative defenses or elements.
What about the general defense of mistake of fact? She also mentioned that in her brief.
Judge Hickson, as I interpret the statutory peg for the mistake of fact offense, it largely exists to negate a culpable mental state. So when you're dealing with a strict liability offense, I'm not sure that mistake of fact is ever really a relevant or appropriate defense. But even presuming it is, even presuming it would have been sort of proper to talk about mistake of fact in the context of strict liability offense, in this case it's just not fairly raised by the proof. All we really have on this, in terms of mistake of fact, is the defendant's, or I believe there's an offer of proof about Ms. Connor, one of the victims in this case, having a fake ID that she had showed to someone at El Mezcal some other time. The defendant. At least from the record, Your Honor. Okay. What there isn't in this record, which would, again, assuming mistake of fact would be a relevant defense, what there isn't in this record is anything suggesting she showed the fake ID on this occasion, anything suggesting the defendant asked her age on this occasion, anything suggesting she told anyone she was 21 on this occasion. And those are the facts you'd really need to support a mistake of fact defense, even construing everything in this record, as we must when deciding whether or not a defense should be charged in the light most favorable to the defendant. Even doing that, there's just nothing in this record showing there is a mistake of fact. What this record shows is that nobody really cared whether Ms. Connor was 21. Nobody asked, and they just provided her with alcohol. The defendant just provided her with alcohol without checking. So I don't really think, Judge Hickson, that the facts and the proof in this case would support a mistake of fact defense, and that's putting aside for the moment that based on the statutory language underpinning mistake of fact, I'm not certain it really comes into play ever for an offense that is strict liability.
Was Mr. Ruiz indicted as a licensee or as an other person, if they even reference the statutory language?
They reference the statute. I don't recall the specific language of the indictment. I know there's a statutory reference. I don't know that they make a specific designation when they charged him.
How did the proof come in? I don't know how the jury was instructed. Was there any proof that he was an ABC licensee?
He was at least an employee of the sort of licensed.
Of someone with a liquor permit?
Of the restaurant has a license, Your Honor, to serve liquor, and he's an employee of them. So that's sort of the proof as far as it concerns Mr. Ruiz being a licensee. And there's not a ton of case law on this specific statute. Perhaps the most notable case that I was able to locate was the Holden case from this court from 2009, which fully supports the state's position that this Title 57 offense is a strict liability offense. And I think the reasoning for that is rather clear. The language just doesn't have a mens rea when it comes to subsection B1A. And I want to note for the court something fairly curious, that in subsection B2B, so just one subsection later, the legislature includes, I believe, a knowing mens rea for showing a fake ID to a licensee to coax them into selling you alcohol. For that crime, one subsection later, just a few lines of code later, the legislature is fully aware how to include a mens rea. They did it in subsection B2B, and they didn't do it in B1A.
And that's evidence, isn't it, that the legislature plainly dispensed with the mens rea element?
Absolutely, Your Honor.
Okay.
I don't know what clear indication the legislature could give us, aside from writing in big, bold letters on the statute, this is strict liability, other than not including a mens rea in one subsection and then plainly including one in the 4 lines of code later.
Right.
This is a very clear indication from the legislature that there is no mens rea in this Title 57 offense. And sort of for these same reasons, the absence of any mention of the affirmative defense, of this reasonable belief affirmative defense in the Title 39 offense is similarly absent from the language of 57.4203. And again, this court should presume, contrary to my friend on the other side's position, that when the legislature doesn't include the affirmative defense in one section and includes it in another code section, that's intentional. And that's exactly what the legislature did here. And what I believe this court must clearly conclude from that is that the legislature didn't include the affirmative defense to be available to somebody charged and convicted under 57.4203, like the defendant was here. I believe my friend on the other side also suggested that somehow the rule of lenity would come into play here to bring in these concepts from the Title 39 offense. Your Honors, this argument fails at sort of the threshold question for arguments based on the rule of lenity, and that's that there actually exists an ambiguity in the statute. Somebody claiming lenity can't just sort of wish cast an ambiguity into existence. They need to be able to point to statutory language and say that language is ambiguous. And frankly, when I examined 57.4203B1A, I see no ambiguity. The legislature very clearly lays out the elements. They very, very clearly do not include an affirmative defense. They very clearly do not include a mens rea. They very clearly reference the Title 39 offense for purposes of punishment only, which is not something that is uncommon, something they do with relative frequency. So I see no ambiguity here, and given that there's no ambiguity, there's no part for the rule of lenity to play. I believe something similar happened in Allman. I believe there was some lenity argument there, and the court rejected it for much the same reasons that I'm suggesting the court reject the lenity argument now. There was some brief discussion, Your Honors, of the trial court's exclusion of Ms. Connor's fake ID on relevancy grounds, and I'll address that pretty quickly. The trial court rejected that on relevancy grounds. That was an appropriate exercise of discretion. As I understand it, that fake ID would have been introduced to support this, mistake of fact defense or the reasonable belief affirmative defense, which doesn't exist in this statute. Things supporting the mistake of fact defense, which is not fairly raised by the proof and is likely not applicable to this strict liability offense, and that would speak to the affirmative defense that is also not applicable to this offense, aren't things that support those defenses simply aren't relevant.
General, let me ask you this. Under 203, if it's strict liability and if there's no affirmative defense, so if a bartender is presented a really good fake ID from a 19 or a 20-year-old and they serve alcohol to that person, are they subject to punishment under 203?
Yes, Your Honor.
No matter what?
That's the statute the General Assembly chose to write. They're the body in this state that decides what the policy of the state of Tennessee is going to be. It's the statute they created. That's the policy they've advanced.
With a 30-day minimum jail sentence, correct?
I believe that's correct. I believe that's my recollection of the punishment provisions is that's right. But the legislature is the body that sets policy. They're the body that writes statutes. I'm sure I'm not alone in this courtroom and occasionally wondering what goes into certain policy decisions, but ultimately we're here in an appellate context reviewing certain decisions made by the trial court. This court, frankly, can disagree with the policy of the General Assembly, but that doesn't affect this court's duty to effectuate the policy that the General Assembly has written in its statutes. Unless this court has any other questions about the interplay between Title 57, 4203, and the Title 39 offense, or any of the other issues raised in the brief, I'll rest on my brief for everything else and ask that you affirm. Thank you, Your Honors.
Thank you. Ms. Newton, we'll give you your rebuttal time if you want it.
Your Honors, Judge Hickson's hypothetical that he just asked the General it really highlights exactly what is at issue here, which is fundamental fairness, fair notice, consistent notice, and that a statute not be vague so that citizenry has questions about the legality of their conduct. It would be fundamentally unfair if there were an affirmative defense and mental state defense available to a defendant for conduct under one part of the law, but the same defendant could be held strictly liable for the exact same conduct under a different part of the law. And that's how we know that 57-4-203-B1A cannot in fact stand for strict liability.
How do we know that again? Because what I understood your friend on the other side to say is that ultimately Judge Hickson's hypothetical is a policy question. Ultimately, policy questions are resolved by the General Assembly. And in fact, this court, I think, has no role in dictating the public policy of the state of Tennessee.
Yes, Your Honor, I do understand the distinction, but I think the issue is that we are here to interpret the statute that Mr. Gomez-Ruiz was charged under. If it were to be interpreted to be strict liability and applied that way, the result would be that it could be a vague statute because it has inconsistent notice and allows for unfettered discretion of law enforcement. Law enforcement could proceed under one statute that they would argue is strictly liable or strict liability, and rather than proceeding under another statute with a higher burden that the state would have to prove at trial. That's an issue.
Isn't it true that those who come close to the line bear the risk that they may cross it? Isn't that a maxim that we hear in criminal law from time to time? It seems to me that both of the statutes clearly identify the conduct that's at issue. On the facts of the case, viewing the facts in the light most favorable to the state, it looks like the defendant violated maybe both statutes. The issue, I think, then with you is there was an affirmative defense under one that was not available under the other. But once again, you haven't raised or preserved an issue with respect to prosecutorial discretion.
And Your Honor, the issue with the prosecutorial discretion, it really goes less towards the charging decision and more the manipulation of of the interpretation. If the statute is interpreted to be strict liability and then applied in a way that deprives the defendant of a defense, that's the problematic issue. But regardless of the prosecutor's role in all of this, the state, I would like to briefly circle back. There was a discussion about the facts, which at trial, there was testimony that Ms. Connor was a repeat patron of the restaurant, that she greeted her server with familiarity, that was on video, that she was first served alcohol that evening by a female server. I think the court was obligated to consider that evidence in the light most favorable to the defense and instruct on mistake of fact. I don't think that there had to be testimony. I think that circumstantial evidence is just fine regarding his state of mind and reasonable belief that she was 21 years of age.
Was there, your friend on the other side suggests there's no proof in the record to suggest that the defendant was aware of those facts. So if we were viewing the video itself and you and I came to that conclusion to say, all right, she's being served alcohol by another member of the establishment, that only matters, right, if the defendant is also aware of that fact? Because only then could he claim mistake of fact. So is there evidence in this record that he was aware that she had been served that night?
I believe that the videos, the surveillance in the restaurant is all-encompassing, essentially.
Sure.
And I don't believe there's any dispute that the women were drinking at the booth, that the defendant was seated at the bar very close to the booth and joined Ms. Connor at the booth where she was drinking. I don't believe there's any dispute as to that fact, that he would have had notice that she was drinking that night.
So when your friend on the other side says there's no real proof here that would give rise to a mistake of fact, the rejoinder is he actually saw them being served alcohol, and so therefore assumed that someone else had taken care of the duty to card and to make sure that the person was over 21?
Well, that would be my position.
Sure, okay.
I've got 5 seconds. I wish I had more, but actually I have negative. I'm sorry. But thank you very much for your
Thank you,
questions.
counsel. Thank you very
both.
much. Thank you very much. Thank you.
We'll call the next case.
State of Tennessee versus Vincent Morrison.
General Ward, I didn't realize you were stuck with us all day.